Nearly 5 years after the North Carolina General Assembly passed landmark legislation involving child sex abuse victims and lawsuits, the state Supreme Court could seal the fate for hundreds of victims. In 2019, the state passed the Safe Child Act that allows lawsuits for decades-old child sex abuse claims. But in a few weeks, the state Supreme Court will consider challenges for hundreds of plaintiffs.
So joining us now is Chief Legal Analyst Khalif Rhodes, and we're expected to hear those challenges on September 18th. But the arguments from those fighting these lawsuits raises questions about the revival window's constitutionality.
Constitutionality, I mean, think about it. Typically, you have statute of limitations for both criminal and civil liability. And so you're expecting something that happened in the 90s or in the 80s in some of these cases that it would be barred from having liability. But that's not the case. Once they passed this law, it was a look back, or you could look back for things that they missed, and you got to look at it historically. During that time, there were a lot of things that were missed, and then a lot of stories came to light, and it was after the window. So how do you give someone some type of, reconciliation? How do you ensure that they're able to be made whole? You really can't unless you pass something like this. And so a number of states have done this. New York may be one of the biggest ones that did something very similar. And so the constitutionality, it's a novel question because this is new. You have not had institutions, legislatures deciding like they have done in the last maybe 5 to 10 years that, what, we may have missed the mark. The way our laws were set up, a lot of folks got hurt, and how do we fix it? We got to open up the books and allow them to go back. But I think both sides make great arguments as to the constitutionality because there is no precedent for this except for in the recent history of them doing this in multiple states.
Charlotte-Mecklenburg School Board and also the Gaston County Board of Education, they're part of the 250 or so lawsuits that are out there, and part of the pushback is whether the claims can move forward against the employers or the perpetrators.
And this is, if you look at the language, this is going to come down to the words and an interpretation and the reading of how do the justices look at the writing of the words. It says the perpetrators of the sexual acts. Well, the employers are saying, well, we didn't perpetrate any sexual acts. Our employees did. And if you're looking at normal vicarious liability, an employer typically can't be held vicariously liable. That means responsible for the actions of their employer, their employee, if the employee is doing something outside the scope of their business. And so the employees, if they are molesting and sexually abusing children, that clearly wasn't in the scope of their employment. The argument, even under any standard, would be the employer would not be liable. However, in this situation, it seems like if they knew it was happening, if they were allowing it to occur, if they did nothing to stop it, in a couple of these cases, they were on notice. They allowed the perpetrator to continue to work there 10, 12 years later, and then they reoffended and did something else to another child. And so they're saying because you were on notice and you allowed it, now you're liable. The typical situation is, yes, they would be liable if it wasn't this look back window. And so because that language says to the perpetrator and in the complaint and in their response, both parties have said, we're not the perpetrators. And because we're not the perpetrators, even if they allowed it to happen, even if they were accessories, even if they allowed it and complicit in their disallowance, because they weren't the perpetrators, I think they may have an argument there.
Well, yeah, and you mentioned it's all going to come down to these words that are used in the arguments. But how long do you think a decision could take the state Supreme Court on this?
It shouldn't take long, but if it doesn't take long, here's the other bigger question is at the end of the day, the most similar thing I can look at in recent time is the Racial Justice Act. If you look at what happened there, they said, you know what, this was unconstitutional. We're not going to let it stand. We'll allow it to be, but the state wanted to make sure it was retroactive, that everyone that filed during that time period, their cases were tossed. I think if I had a crystal ball, I think the Supreme Court would say, you know what, we're going to shut this down, but everyone that filed within that time frame will be able to do it. And I think it will be in short order because these insurance premiums are going to go through the roof. If you can be held liable indefinitely for 40 to 50 years instead of for 3 to 5 years, now you're paying a lot of insurance because the insurer is going to be on the hook forever, basically.
Yeah, a lot of people impacted by this, of course, especially when you look so far back. So we'll see what the state Supreme Court does with it. Khalif, thanks.